and welcome. My name is Kristen Calvi, and I am the editor of CCBJ. We are thrilled to be working with our partner, National Arbitration and Mediation, or NAM, to present today's webcast, Introduction to Admiralty Law and the Use of ADR in Resolving Maritime Disputes. I'm pleased to introduce you to the Honorable John G. Ingram, retired Justice the Supreme Court, Kings County, New York, Maritime Law Specialist. We encourage you to ask questions as well as fill out the survey with your feedback at the end. All of this can be found in the icons at the bottom of your screen. Judge Ingram has had a long and remarkable legal career, both as a judge and as a litigator practicing Admiralty Law. He has successfully litigated hundreds of cases representing container ship companies, cruise ship owners, terminal operators, passenger and harbor workers, seafarers, docking pilots, and a major towing company, and the Port of Albany. Judge Ingram's interest and deep understanding of maritime law stems back to his undergraduate studies at the State University of New York Maritime College, where he graduated with a Bachelor of Science in Marine Transportation. After graduation, he joined the United States Naval Reserve and sailed on his license aboard U.S. flag freighters, container ships, and passenger liners as a third and second mate. He holds a third mate's license for continuity issued by the U.S. Coast Guard. Thank you for joining us, Judge. It's our honor to have you here. I will turn things over to you, and we really look forward to your presentation.
Good afternoon, and welcome to the Introduction to Admiralty Law. I know that my good friend Ed Murphy down in Texas is watching this, so I guess it's still morning down there, but we are pleased to put on this presentation. I know that some people have a lot of experience in maritime law and some are pretty much neophytes. So I'm going to try to give you a general intro to Admiralty Law. Please feel free to send any questions, and we will proceed. The law of admiralty may be defined generally as the body of rules, concepts, and legal practices governing certain important concerns of carrying goods and passengers by water and the related torts, including collisions, salvage, personal injury, wrongful death, cargo damage. When the Constitution was formulated, the English Admiralty courts existed in the colonies, and these courts heard disputes arising from naval or maritime matters. In fact, they were the predecessors to our state courts. The sources of Admiralty law would be the Constitution of the United States, particularly Article 3, Section 2, which stated that the judicial power shall extend to all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made or which shall be made under their authority, and to all cases of admiralty and maritime jurisdiction. Next, we have the Judiciary Act of 1789, which was amended in 1949, which provided that the U.S. District Courts shall have original jurisdiction exclusive of the courts of the states to any civil case of admiralty or maritime jurisdiction. And this is where it gets important. Savings to suitors in all cases, all other remedies to which they are otherwise entitled to. And the judiciary and judicial procedure of the United States. So before going to the next slide, Jennifer?
Yes, Judge Ingram. So can you tell us, can maritime cases be commenced in state courts?
Yes. In many jurisdictions, the plaintiffs, particularly in personal injury cases, like to bring cases in the state courts because it is believed that in many cases the juries may be more generous in state court than federal court. So based upon this savings to suitors clause, if the state court is competent to give the remedy, and if the remedy is money, someone is just suing for damages for personal injury or cargo damage, they can certainly bring those cases in state court. Certainly a limitation case, limitation of liability, cannot be brought in state court. That only can be brought in federal court. So the state courts, and many times state judges don't even realize that they do have jurisdiction if the parties are subject before them and there's personal jurisdiction and the damages sought are just money. So the one of the key things in Admiralty Maritime is in rem actions. That is, an action in rem in the United States is commenced by arresting property, typically a vessel, under supplemental rules C and E of the Federal Rules of Civil Procedure in U.S. district courts where the property is located. One of the key things in Admiralty is that even before there is any determination of liability, a party, in order to obtain jurisdiction and security, can arrest a vessel. It's a procedure. You have to go to the U.S. District Court. After the judge signs the order, the U.S. Marshal will go to the ship and put the plaster in the bridge and on the mast, and the ship cannot leave the port until sufficient security is posted, or if it is a so-called a P&I club matter, the club can issue a letter of undertaking so that the vessel can be released. People don't do that because willy-nilly, in that it's an expensive procedure, because the U.S. Marshal will request security in advance to be paid by the arresting party. They want money in advance to cover their insurance, the placement of guards, the wharfage of the vessel while it's under arrest. So it's a very serious thing to arrest a vessel in rem. And of course, the vessel owner can seek counter security from the arresting party for what might be deemed to be a wrongful arrest. So the maritime liens can be a lien for seafarers' wages. The in rem action may be brought to enforce maritime liens under the Federal Maritime Lien Act, to enforce other maritime liens created under the general maritime law and as authorized by federal statutes, such as under the Federal Ship Mortgage Act. Now, while there is no definite ranking of maritime liens, the following give rise to maritime liens: a seaman's claim for wages, a master's claim for wages, salvage claims, maritime torts, including collision and personal injury claims, general average claims, a preferred ship's mortgage, that is, a U.S. preferred ship's mortgage gives rise to a maritime lien, which takes precedence over supply and repair liens. There's also maritime liens for towage, for wharfage, for pilotage, for stevedoring, etc. There's also maritime liens caused by damage to cargo, caused by improper loading, stowage, custody, etc. And a ship owner would have a claim against cargo for unpaid freight, which gives the ship the right to arrest the cargo and proceed in rem against the cargo for payment of the freight. A breach of a charter party, as many of you know, most ships are leased out. It's called chartered. There's three types of charter. There's a bareboat charter, there's a time charter, there's a voyage charter. The bareboat charter basically had the charter of the party leasing the ship has all incidents of ownership. The time charterer, the charterer pays per day or per month for the vessel. And the voyage charter is like calling your Uber for a trip from your home to the local stadium. So you pay for the trip. So, but a breach of those charter parties gives rise to a maritime lien. And we'll talk later about most of those charter parties do provide for arbitration, and we'll talk a little bit about that. So, Jennifer?
So, Judge Ingram, can a U.S. seafarer be required to agree to arbitrate her personal injury action as part of their employment contract?
Good question. A U.S. seafarer employed on a U.S. flag vessel cannot be required to waive arbitration as part of the employment contract. In other words, the seafarer has a right under the Jones Act to sue the vessel owner for negligence and have a jury. And if they go to a state court, that cannot be removed to the federal court. Interestingly, once a suit has been filed in federal or state court under the Jones Act for negligence, and also it's normally combined with a claim for unseaworthiness, and that can be brought in the state court as well. The seafarer, represented by counsel, can agree to arbitrate their claim for damages. I just sat on an arbitration. Well, it's actually that was a mediation recently, where it was a claim by a seafarer under the Jones Act. So once the suit has been commenced, the parties can go to mediation or arbitration. I think that answers your question, John.
I have just one more follow-up on that. Your Honor, can a foreign seafarer sue her foreign flag ship owner under the Jones Act in U.S. district courts, and can they agree in their employment contract to binding arbitration of all claims arising out of their employment, including claims for personal injury?
Under the holding of Rhoditis versus Hellenic Line, foreign flag seafarers can sue under the Jones Act their U.S.-based employer, even though they sail on a foreign flag ship. So they have the right to sue under the Jones Act. However, most seafarers contract with U.S.-based, for example, the cruise ships. Nearly all of the cruise ships that sail from U.S. ports, East Coast, West Coast, Gulf, are foreign flag ships. Most of the seafarers on board those ships are foreigners, that is non-U.S. seafarers, and pursuant to their employment contracts, they agree to arbitrate their claims for personal injury, wrongful death, or anything arising out of their employment on board those cruise ships. There was a decision that just came down literally 2 weeks ago, which I was fortunate to receive from the Maritime Law Association, a case called Maglana, M-A-G-L-A-N-A versus Celebrity, which was a class action brought by Filipino seafarers against Celebrity Lines, basically for wrongful detention due to the COVID pandemic. In other words, the claim alleged that there were some 1,700 Filipino seafarers being held captive aboard Celebrity's ships, and nearly 7,000 Filipino seafarers employed aboard Royal Cruise Lines, and as Amara Cruise Line, Celebrity Lines, and other subsidiary brands owned by Royal Caribbean. The case was pending in the U.S. District Court for Southern District of Florida, And U.S. District Judge Jose Martinez ruled that those seafarers had agreed to arbitrate all claims arising out of their employment pursuant to their contract of employment. And in a very well-reasoned opinion, Judge Martinez dismissed the case and said that the parties were to proceed to arbitration of all of their claims. So the court held it was a binding agreement. The dispute certainly arose out of their employment, and the arbitration agreement was enforceable under the Convention on the Federal Constitution and general maritime law. So that decision was just rendered on the 7th of October 2020 by Judge Martinez. So it's a great decision for the cruise lines. Just today, I received notice from the Maritime Law Association that a class action brought by passengers who were kept aboard Princess cruises and were because of the pandemic, that class action was dismissed because of the contract, the passage contract. Passage contracts are enforceable, particularly the venue provisions and passage contracts. And many of the passage contracts provide for arbitration of disputes arising out of the contract of passage, except for personal injury, So I trust that answers your question.
Thank you very much.
Okay. So I did mention about the in-rem action and the enforcement of maritime liens and mortgages in the United States. And so one of the questions comes up is this constitutional? Well, of course, it is constitutional, but why do we have such procedural rules in Admiralty to allow for the arrest of ships? As everyone knows, shipping is an international business. So it may be a Liberian flag owned by ship owners out of Athens, Greece, who have office in London, and the ship comes into the United States. And the reason that we have these special procedural rules is to obtain jurisdiction of the vessel and to obtain security for any judgment. So it's because of the special nature, the transient nature of the shipping business, that we have special procedural rules to allow a plaintiff to obtain jurisdiction in a U.S. district court. We also have Rule B attachments, which basically provide for the supplemental Rule C specifies the procedures for in-rem procedures, which is the complaint, judicial review, notice, the claimant's response, the execution of the process. In-rem proceedings can only be brought in U.S. district courts to obtain jurisdiction and to obtain security for any eventual judgment. Again, I remind, I'm sure everybody listening who knows that an arrest should not be made willy-nilly. It's a very disruptive process. It can have a very adverse impact on the future business dealings of the ship owner when his ship, her ship is held in port. There is an alternative method for obtaining in personam jurisdiction other than by process on the defendant or his agents. And that is what we call a Rule B attachment, which can only be made against property or monies being held in the district as long as the defendant does not have a presence in the district. So, for example, if a plaintiff has a $10 million claim against a ship owner and the ship owner cannot be found within the U.S. District Court's venue, then if that ship owner has a property, it can be attached in the federal court. So what property are we talking about? If, for example, there is charter hire, money paid for the use of a ship, for the lease of the ship, if it's in a bank account in, say, New York, well, then the ship owner is not present within the Southern District of New York, then a Rule B attachment can be effected in order to obtain limited jurisdiction. So, for example, if it's a $10 million claim and you're able to attach $2 million, well, then you have in personam jurisdiction up to $2 million. And if you're successful, you can execute against that $2 million, which is being held. And then you have to go someplace else for the balance of your $8 million. So the maritime torts, what are maritime torts? Well, the classic one is injuries to seafarers, injuries or wrongful death of passengers, injuries or wrongful death of longshore and harbor workers, and I'll go into each one individually. As we said, U.S. seafarers can sue their employers for personal injury, and their states can sue for wrongful death. Now, that's kind of unique, as we all know. Based upon the FELA, which gave railroad workers the right to sue, seafarers under the Jones Act can sue their employers for personal injury or wrongful death. In addition, seafarers are entitled to what is called maintenance and cure, which is sort of a workers' compensation, but it's not truly workers' comp because it's not administered by any state or federal agency. But what maintenance and cure is, that it's the ship owner's obligation, regardless of fault, to provide for medical care, that's the cure, and maintenance to the seafarer while they are recuperating from injuries or illnesses. And under a very recent, well, not too recent, Supreme Court decision, if a ship owner wrongfully refuses to pay maintenance and cure, they can be subject to punitive damages, which is something that most good ship owners and most good claims people do not willy-nilly cut off a seafarer's rights to maintenance and cure. They are entitled to, in addition to wages to the end of their voyage, and also to repatriation to their home port, and also for ongoing medical treatment until they are found either fit for duty or permanently unfit for duty. So it's very serious on the ship owner's part to cut off a seafarer from his medical treatment and maintenance while recuperating. Most union agreements for U.S. seafarers set forth an amount for maintenance. Most contracts today still have the archaic amount of approximately $40 per day for maintenance, while a seafarer is off the ship and not in a hospital and is being treated. So the maintenance and cure is not governed by questions of fault, although there are some cases that say willful misconduct will preclude the award of maintenance and cure. The only example I would give is where a seafarer would be intoxicated and decide to go bungee jumping and not properly affix the ankle harness and messes him or herself up. Or surfing on a subway car in the Bronx. We had a case of that not too long ago. But anyway, so seafarers are entitled to maintenance and cure. In most cases, a ship owner will not cut off a seafarer for maintenance and cure while still undergoing treatment of a curative nature. Of course, once a seafarer reaches maximum medical cure, that is where medical treatment cannot in any way improve his or her condition so that they can return to work, they can be found permanently not fit for duty. And that basically cuts off the ship owner's obligation. So there's no workers' comp that would pay like for a longshore harbor worker for a permanently unfit person. As I say, that seafarer can sue for personal injuries under the Jones Act and combine it with a claim for unseaworthiness. So what is unseaworthiness? Unseaworthiness means something or some person is not fit for its intended purpose. In other words, a ship owner, a seafarer warrants to the ship owner that he or she will will sacrifice his or her life to save the ship and cargo, and the ship owner warrants that the ship and its appurtenances and personnel will be reasonably fit for their intended purposes. Some courts say it's liability without fault. Others say that a ship owner does not owe a seafarer an accident-free ship, but that the reasonable standards, the Jones Act has a very lax standard, very pro-plaintiff standard for negligence. If the ship owner's, the employer's negligence in the slightest will give rise to liability. Under the Jones Act, even before the law of New York changed, the Jones Act always provided for comparative fault. So even if a seafarer is found, say, 60% at fault, he still or she still would make a recovery of 40% of the damages awarded by the fact finder. That could be the jury. In most cases it is. It could be tried to a judge without a jury. And it's interesting that in a wrongful death action, it is the pecuniary loss to the survivors. And of course, if the seafarer is single and does not have any dependent relatives or children, then there is no pecuniary loss. So it's something to be aware of. But the Jones Act is pretty much very pro-plaintiff because of the nature of the hazards that seafarers anticipate and work with. So the passengers, a lot of times passengers, the question came up, what are passengers owed? Are they owed the highest degree of care? Some of the Florida state courts used to hold that, but the law which governs most passenger cases in the United States is Kermarac versus French Line, which basically provides that the ship owner owes a duty of reasonable care to all persons who are aboard their ships. So in other words, it's basically a standard of negligence. Passengers cannot sue for unseaworthiness. They can only sue the ship owner for negligence. So there's quite a few cases. The passage contracts usually provide that the cruise ship can only be sued in the venue selected in the passage contract. And that has been upheld by the Supreme Court of the United States. And in a case called Carnival versus Schutte, which basically held that the forum selection clause, even though, say, a passenger books a cruise in New York City with Liberty Travel aboard a Princess cruise ship sailing out of the Port of New York to Bermuda and back to New York, if that passenger who lives in New York is injured, that passenger must bring the suit for personal injury in the venue selected in the passage contract, which I believe in Princess case may be California. Norwegian is Florida. Carnival, for the most part, is Florida. Holland America is Seattle. So people have to carefully look at where those actions may be brought. Interesting issue of when a U.S. Passenger sails on, say, a Costa ship that sails from Genoa, Italy, on a Mediterranean cruise to begin in Genoa and end in Genoa, and is injured on that ship, they must bring their lawsuit in Genoa, Italy, and cannot bring their lawsuit in the United States because, for example, the Costa line contract provides for all passengers who board their ships in Italy for a Mediterranean trip, beginning and ending in Genoa, they must bring their lawsuit in Genoa. So that's very important to keep in mind. So passengers can be required, pursuant to the passage contract, to arbitrate certain claims against the cruise ship line, and that is set forth in the passage contract. And those claims, other than personal injury and negligent infliction of emotional harm, can be required to go to arbitration. However, personal injury and claims for alleged sexual assaults and intentional infliction of emotional harm cannot be required to go to arbitration. But it's something that passengers should be aware that if they and lawyers representing them should be aware that they should check the contract, the passage contract, which some people call the ticket, so that they are required to arbitrate. So next we'll talk a little bit about longshore harbor workers. At one time, longshore personnel could sue the ship owners for unseaworthiness based upon the theory that they were doing the same work that was traditionally done by seafarers, so that is loading cargo and discharging cargo. In 1972, the Longshore Harbor Workers Compensation Act, 33 U.S. Code, Section 901 to 950, provided a federal workers' compensation scheme for maritime workers who do not qualify as seafarers and who are involved in the loading and discharging of cargo from ships, and also shipyard workers and other repair type people, with some exclusions for security guards and marina workers. Those people, longshore harbor workers, and you could have longshore personnel, you could have checkers, you could have terminal operators, people who work on terminals, people who work in shipyards. They are now covered by a federal workers' compensation known as the Longshore Harbor Workers' Compensation. And it's administered basically by the U.S. Department of Labor, and those people who are injured in their line of work are entitled to a very generous compensation scheme, which is set forth in the federal statute. One of the key things is that the comp paying employer, whether it's the stevedore company, the shipyard, the terminal operators, once they have that compensation scheme in place, they, the employer of the injured waterfront longshore worker, cannot be sued. And any agreement to the contrary is deemed to be void, because this was to replace what used to be known as the Ryan Triangle, and I won't go into that, but some of you who are on may remember the Ryan Triangle, where the employer got stuck twice, once for very generous compensation and once for indemnity from the ship owner. Today, a comp-paying employer is immune from suit. However, the waterfront worker or his or her estate can file a suit against the ship owner or other tortfeasor other than their employer for their injury or death. And it's basically a common law standard of negligence. And the only thing is that if the party being sued, whether it be a ship owner or, say, a marine carpenter whose negligent employees caused injury to a longshore person, they cannot seek indemnity from the injured longshore person's employer. The liability is exclusive under the Compensation Act. So I believe so I think, what is the merchant marine? I guess that's a good question. Some people think as the merchant marine as the fourth arm of defense, and certainly during major wars, the merchant marine did carry the butter and bullets to the troops at the front. Today, the merchant marine encompasses certainly seafarers working aboard container ships, dinner boats, the tankers, tugboats, all of the dry cargo, car carriers, bulk carriers. So the merchant marine is a civilian agency. Basically, most of the U.S. flag mariners are engaged through unions, and they have union benefits as well as benefits under the law. And they are a very vital part of the commerce of the United States. Coastwise trade, for example, must be carried out on U.S. flag vessels. Foreign transit of cargo and personnel can certainly be done by foreign flag vessels with foreign crew. I won't talk too much about piracy. That could be for another lecture sometime. But the U.S. Constitution basically states whoever on the high seas commits the crime of piracy as defined by the Law of Nations and afterwards brought into or found in the United States shall be imprisoned for life. I just was reading recently that in the Gulf of Sudan, piracy is on the rise. If anyone wants to watch a great movie, the Maersk, Alabama, Captain Phillips, portrayed by Tom Hanks, is a fantastic movie, very well done. And the pirate who was captured, you may recall that it was on Easter Sunday, probably about 5 or 6 years ago, that Obama gave the order, shoot to kill, which the SEALs did from the deck of the Bainbridge, and killed 3 of the pirates, and thereby saved Captain Phillips' life. And the pirate was brought back to New York and brought into Stewart Air Base up in Stewart, New York, and he was tried in the U.S. District Court for the Southern District of New York as a pirate. And Judge Loretta Preska of the Southern District sentenced him to 35 years in prison. And so piracy is still very real today. It's the ship owner is usually covered under its war risk policy for piracy, and more about that at some other time. And certainly any disputes coming under that marine insurance policy could go to arbitration if the parties consent thereto. So the piracy is still very much in the vogue, and some shipping companies have placed armed guards on board their ship as they transit piracy waters, which brings up all kinds of very interesting international legal questions regarding weapons aboard merchant ships and the people who carry out those duties. For another day.
Thank you, Judge Ingram. So may I ask a question?
Oh, sure. Jump in.
Great. So can you talk about, can the parties agree in the charter party to a sole arbitrator?
Aha. Good question. Most charter party disputes are arbitrated primarily in New York or London pursuant to the charter party. I think I briefly mentioned there's three types of charters: bareboat, where the charterer basically assumes all of the functions of owner and actually can petition to limit liability in the federal court, which is a whole area. But also the time charter or the voyage charter can, and most charter parties do provide for disputes to be arbitrated either in New York or London. Now, there's two separate sets of rules. There's the London Society of Maritime Arbitrators and the Society of Maritime Arbitrators out of New York City. The charter parties can provide for arbitration by a three-person panel, one to be chosen by the owner, one by the charterer, and those two can choose the so-called neutral or umpire. The parties could agree, if they so desired, to arbitrate before a solo arbitrator. Most disputes, however, are by three arbitrators. So even though the charter party might provide that all disputes to be arbitrated in New York pursuant to the rules of the Society of Maritime Arbitrators, the parties are free to choose their own arbitrator if it is not otherwise stated in the charter party. Some charter parties do provide for selection of the arbitrator from the list of the Society of Maritime Arbitrators or the London Society of Maritime Arbitrators. If the agreement is silent, then a party can choose a non-SMA arbitrator or non-LSMA arbitrator. And that arbitrator would be required to follow the rules of whatever arbitration society the parties have agreed to. So in other words, if the charter party stated that the parties must follow the rules of the Society of Maritime Arbitrators, the parties are free to choose an arbitrator who is not a member of the society. So the answer to your question is yes. They can choose an arbitrator, not a member of the society. For example, the rules of the SMA state that you cannot be a practicing lawyer within 10 years to be a full member of the society. So depending on the nature of the disputes, the parties may wish to have a a party arbitrator, not a member of the society. That's a matter of choice. Okay, did that answer your question? I hope. Okay. One of the things, let's see. This very recent, I got to look at my time. Keep an eye on my time, I know. There was a very recent safe berth case, which was finally decided by the U.S. Supreme Court after 16 years in litigation. 16 years. The case is well known to many of the maritime lawyers and entities. It's called Citgo Asphalt Refining Company versus Frescati Shipping Company, and involved the tanker Athos 1, A-T-H-O-S, Athos 1. The facts briefly are that Citgo was the voyage charter and owner of the refinery on the Delaware River. The ship owner had entered into a time charter, which provided that the time charterer would exercise due diligence to provide a safe berth. The time charterer entered into a voyage charter with Citgo to carry the cargo to the refinery on the Delaware River. The obligation under the voyage subcharter was that the charterer, the facility, was to provide a safe berth. So that was deemed to be a safe berth warranty. When the tanker Athos was approaching the terminal in the Delaware River, its single hull was torn open by an anchor that had been lost or abandoned by some unknown ship years before. The anchor was on the bottom of a federally maintained anchorage. The anchor, which was previously undiscovered, had been present for at least 3 years. Apparently, the flukes of the anchor were down and somehow flipped over prior to the Athos arrival, and ripped open the ship's hull, rupturing several cargo tanks. An estimate of approximately 263,000 gallons of Venezuelan crude was spilled into the Delaware. Cleanup and loss of revenue claims exceeded U.S. $180 million. The ship owner brought suit against Citgo, and Citgo was the charterer and wharfinger, that is, it was their terminal, and the ship claimed that it was the third-party beneficiary of the warranty of safe berth, and were sued the Citgo for breaches of the warranty of safe berth and for breaches of the duty to properly maintain its berth and approaches. The case was bench tried for 41 days in the U.S. District Court for Eastern District of Pennsylvania. The judge found no liability on the part of the terminal, that is Citgo. The Third Circuit reversed. The court held that the Citgo breached the warranty of safe berth. In other words, it was a guarantee. The Third Circuit declined to follow the Fifth Circuit, which had held the charterer was to exercise due diligence to provide a safe berth, relying on the Law of Admiralty by Gilmore and Platt. The Third Circuit chose to follow the long line of cases by the Second Circuit. The case was reversed and sent back for a new bench trial with a different judge who held charterer Citgo liable for breach of warranty of the safe berth. Thus, you had a conflict between the Third Circuit and the Fifth Circuit had arisen, and the U.S. Supreme Court granted writ of cert, and the case was finally argued in 2019. And the U.S. Supreme Court rendered its much-awaited decision in March of 2020 in favor of the vessel owner and held that it was a guarantee, not a due diligence on the part of the charterer or terminal operator. This case had been pending 16 years before final resolution was had. I'm certain that if this case had been arbitrated, it would have been resolved much sooner than 16 years. In fact, many of these safe berth warranty cases have been successfully arbitrated in New York following the Second Circuit's guidance. And in most cases, the safe berth warranty, depending on the language, was held to be a guarantee. So, as I say, most of these cases are arbitrated, and for good reason. 16 years to wait on a case involving well over $180 million is a hell of a long time. Mediation is also a beneficial alternative. The benefits of mediation are obvious. Disputes can be resolved in an expeditious, economical, and confidential fashion. As I said, even after a Jones Act case that has been instituted, the parties can agree. And in many courts today, they are encouraging, and in some courts requiring mediation. And it certainly makes sense to mediate a maritime case before a maritime mediator who is very familiar with the facts, circumstances surrounding maritime type cases. And the maritime bar is a very small bar, and the lawyers many times know each other and know the arbitrators or mediators. But flexibility is a valued benefit that mediation affords counsel, providing the ability to schedule the time, day, and location of the mediation, and can eliminate protracted litigation and being bound by the timeliness of an often backlogged court system. We all know that state courts, particularly in New York, are trying to get back to jury cases. In fact, I believe next Monday they're going to try their first civil jury trial in the city of New York under very strenuous situations as far as jurors, and some of it will be done virtually, et cetera. But even jury selection today will be a nightmare. So mediation can be facilitated in a time-controlled environment that will afford the parties comfort that they will not be negotiating blindly or in a vacuum for years, thus reducing the cost of attorneys' fees. Confidentiality mediation allows the party to resolve their disputes while keeping sensitive information that could damage the reputation of any of the parties to the agreement. So mediation also allows the parties to select the neutral of their choice. Admiralty law is a highly specialized area of the law. Mediation allows the party to choose a neutral with a specific expertise and, in many cases, background and experience in the dispute or the types of ships or tugs or situations involved that cause injury or damages. Certainly personal injury by crew members, certain right for mediation, passenger claims for personal injury are also ripe for mediation, and certainly marine insurance disputes are ripe for mediation, especially with a mediator who has had background and familiarity with marine insurance. In the United Kingdom, they have a national British Marine Insurance Act. The United States, we don't. Marine insurance in the United States is governed by local state insurance laws. And certainly if it's something that is particular to maritime, such as general average or utmost good faith, which are basically maritime things thrown on top of marine insurance, those marine insurance disputes are ripe for mediation. The arbitration of maritime cases is, as I say, not only the cargo cases or charter party cases, salvage cases, particularly today in the United States. Pleasure boat salvage is a big field. At one time, and it was crazy, that if going back, I think it was 1982, that President Ronald Reagan said the U.S. Coast Guard should not be operating a towage service for pleasure boats in U.S. waters. In other words, in those days, the Coast Guard used to, come out, put a line on a pleasure boat, whether it's a cabin cruiser, a yacht, a fishing boat, and tow it to its marina, which was very nice. But the administration said that should be a private enterprise. So companies such as Sea-Tow and other pleasure boat salvers came into existence. And when they got a call that a vessel was in distress, they would respond. Many times the Coast Guard would respond, and after making certain that the vessel was secured to a buoy and there was no threat of imminent harm to the passengers, crew, etc., they would leave it tied up. Sea-Tow would come along. If the parties had the appropriate salvage insurance, they would take the tow and tow it in. If they didn't have insurance, Sea-Tow would require them to sign a salvage agreement, which provided that in the event that the parties could not agree on the value of the salvage, that the case would go to arbitration in London at the Trinity House. Well, of course, the courts found that to be a very unreasonable. So now such pleasure boat salvage cases provide for arbitration, and most cases by a solo one arbitrator. And matter of fact, I have one where the papers are due next week on submission by the salvor, and then the vessel owner, the yacht owner, will submit its papers 2 weeks thereafter, and it will be solely on papers, no argument, no live witnesses, and it's called the small claims salvage matter. So those cases are ripe for arbitration because they can hopefully get a quick, well-reasoned opinion from an arbitrator who hopefully knows something about salvage. And so, as I said, salvages, especially pleasure boat salvages, personal injury, passenger claims, cargo claims, marine insurance claims, the claims for towage and pilotage, they too are ripe for arbitration if the parties agree to same. So I believe I'm just about out of time. I see my clock is ticking, but if there are any questions, I'll try to answer them. Do we have any questions?
Yes, we do have a couple of questions from the audience for you.
Okay.
I'll start with the first one that came in, which is, at what point in the sea does the United States lose jurisdiction?
The jurisdiction of the Admiralty Courts of the United States to the navigable waters of the United States, that is all waters connecting to and from the United States, are navigable waters of the United States. Thus, a collision that occurs in the English Channel between three foreign flag ships is subject to the Admiralty jurisdiction of the United States District Court. So the interesting thing about Admiralty is that it doesn't have to happen in U.S. waters. If something happens in a wholly land-like state, a lake like Lake George, it's not subject to Admiralty. But a collision off South Africa is subject to the Admiralty law of the United States. The parties can bring, for example, there was a three-ship collision in the English Channel. Cargo interest brought suit in the United States. All three ships came to the United States. They were represented by eminent counsel in New York, and the case proceeded in the U.S. District Court for the Southern District of New York based upon the court's Admiralty jurisdiction, which connects to all waters to and from the United States, including the Indian Ocean, Pacific Ocean, Antarctica. So, yes, next question.
So how do you see COVID-19 changing the future of the legal landscape in the cruise industry, if at all?
Great question. And I know that many of my friends in the cruise industry, including my former client, Holland America, they're all very concerned. First off, they are concerned for the welfare of their crew, their passengers, who they call their guests. And as I said, there was just this very recent case that was decided today or yesterday against Princess, which basically tried to have a class action against cruise companies. And the court in California, the U.S. District Court, dismissed it and said those types of claims must be brought pursuant, they can't be brought pursuant to a class action. Individual passengers who came down with COVID and can certainly trace it to the ship may have a cause of action against that ship owner for negligence. But we have to see what's going to come out of the legislation now pending in Congress about whether there will be immunity granted to carriers. However, stay tuned to that. But the crew members, as I said, they will have to arbitrate their claims for personal injury and for wrongful detention on board the ships. I mean, I know a lot of the ship owners did try to make efforts to repatriate their ships. And in some cases, they actually loaded cruise ships with seafarers from Philippines and from Indonesia and brought those seafarers back on cruise ships to their native countries just to get them home so that they could not be held hostage on board these ships because the cruise ships weren't permitted by U.S. officials to discharge crew members in U.S. ports. So it's going to have an impact on the business. Certainly, hopefully, once we do have a vaccine, that things will return to what we like to think was normal, and that the cruise industry and the other leisure industries can get back into business with safety for their passengers, guests, and certainly their crew.
Excellent, thank you. This is my last question from the audience. If piracy occurs in international waters, is the jurisdiction based on the vessel or the place of the dock?
Good question. In fact, pursuant to our federal law, piracy is a crime against all nations. So if anyone is apprehended, no matter where in the world, they can be brought back to the United States to be tried. The U.S. Navy, as part of a task force, many times would pick up pirates and in some cases have them brought to, say, Mombasa in Kenya for trial. The Royal Netherlands Navy, when they picked up pirates, they basically took the position they could not take them back to the Netherlands for trial because their law did not allow it. Our law certainly allowed for the extradition of the pirates with the Maersk, Alabama, to be brought to the one pirate to be brought to the Southern District of New York. Of course, that was a U.S. flag vessel, and it was a U.S. crew involved, who I understand some of whom decided to sue Maersk under the Jones Act, but that's for another day. So the answer to that question is that there is jurisdiction under our federal law for piracy, for pirates to be brought back to the United States to be tried. In fact, there was a case out of Virginia, U.S. District Court, Virginia, where a negotiator who was trying to negotiate the ransom was actually brought to Virginia and placed on trial. So there's I have a whole presentation on piracy if you folks think it might be worthwhile. So, which will, I believe, end this session. It's been my pleasure to talk to all of you. I hope you all stay safe. Wash your hands, wear your mask, and we shall survive and overcome. Fair winds, following seas, and God be with you all. Stay safe.
Thank you so much for your presentation today, Judge Ingram. We really appreciate it. For our audience members, there's a brief survey for a little feedback to help inform us for future broadcasts. We hope you'll take the time for it. Judge Ingram, I always appreciate having you and your colleagues on for webcasts and interviews. It's always super informative, and we thank you for taking the time and putting together such an incredibly informative presentation.
My pleasure. Thank you. Stay well.